Bill 288.
288.
An act to amend section 21205 relating to the duties of chairman of boards of elections commissioners and place a name on ballot for public welfare cause.
Mr. Barry, you're recognized.
Mr. Speaker, ladies and gentlemen of the House, at the present time, Section 21205 of our branch ballot law governing placing of names on election ballots provides that ballots printed for use under the provisions of the law shall contain the names of all candidates who have been put in nomination by any caucus, convention, mass meeting, or other assembly of any political party in the state at least 30 days previous to the date of election. Because of some circumstances that have arisen in the past and might recur in the future, it has been felt desirable on the part of the Attorney General's office and the election officials of the state to further define the term political party. And that is the purpose of this proposed amendment. We would define political party as used in that section as a party whose regularly nominated candidate has received in a statewide election as many as 10% of the votes cast in the next preceding election of presidential electors, or which has a membership equal to 5% of the votes cast in such an election. Now, the reason for that is simply this. It is to prevent the names of individuals appearing on ballots under a party label, when the party itself may have been created or brought into being simply by the meeting of 2 or 3 people in an isolated circumstance. This does not in any way affect or impair the provisions of the following section, which allows any individual independent candidate for office to qualify and have his name placed upon the ballot by filing a petition with the names of at least 25 qualified voters thereon. It simply makes it more difficult to define the political party and make it more likely that the individual representing the party sincerely does so. Are there questions, Mr. Speaker? Mr. Galbert?
Will this affect the creation of any new party? Well, I recall a little before my time there was Free Democratic Party that put some very, very distinguished gentlemen on our appellate benches. What would that do to an effort in the future now I'm a Democrat, and I respect my Republican friends, but there are times, and there have been times in the history of this state, when there was a need for someone to run against Democratic and Republican candidates. How would that affect that?
I will do my best to explain it, Mr. Galbert. As I say, the second section of this particular act, which is Section 21206, provides that any candidate can qualify by filing a petition with the names of at least 25 people. That does not in any way change that. I want to make that clear. But now, for this purpose, we would simply define political party in this state as for the purpose of establishing their right to nominate candidates by caucus, convention, mass meeting, or other assembly as a party whose regularly nominated candidate has received in a statewide election as many as 10% of the votes cast in the preceding election of the presidential electors, or which has a membership equal to 5% of the votes cast in such an election. We want to make a party more of an actual party than it has frequently appeared to be in fact.
Well, how would this new political party go about establishing the fact that it had 5% of the... Wouldn't that put a great burden on some new party? How would they prove the percentage of the membership of that party?
I can answer that in the language amendment as follows. As shown by petitions signed by qualified voters for the purpose of establishing a political party. You'll find that in about the 8th line of the proposed amendment.
Well, 5% of the qualified voters of Tennessee would run over 20,000.
That is correct, sir. That is correct. It is felt that at least that number should be entered if we are to establish a reliable and substantial type of political organization.
What would this do to the prohibitionist parties, the states' rights parties, and all of these other parties?
I believe those are already established, Mr. Galvin.
Oh, this would not have an effect on a previously
established. As I understand it, those are accepted, established. This is apply only the future.
Even though a party in the past may have only had a few members, they could still put on the ballot the candidate of those parties?
That, I think, is not the case, Mr. Galvin.
I just think it's inherently wrong to try to restrict the formation.
I'll be glad to hear the gentleman's any remarks, Mr. Speaker. This
Don't
will be
you?
question time.
Made that a question.
There are two gentlemen standing up. Mr. Reinhardt.
Mr. Speaker, I move the previous question on passage of the bill.
Well, now, Mr. Barry not yielded the floor.
I'll be glad to yield to the gentleman, Mr. Speaker.
Have
in
you
order to
yielded?
question. I'll be glad to yield to the gentleman, certainly. I move the previous question on passage of the bill, Mr. Speaker.
Well, now, Mr. Reinhardt, just a minute. I'm going to put your motion if you insist on it. Mr. Neighbors was standing for a question. Do you withdraw your motion for that?
I withdraw my motion then, Mr. Speaker.
All right, Mr. Neighbors.
I yield, sir.
Want to know if, of course, Mr. Galbraith indicated we got crackpots that have run, and I don't mind naming the man, this Freeman Porter, for one. Is he qualified now to be on the ballot this next time?
No, sir. It's my understanding that he's not.
He's not a recognized.
He could if he established his political party in accordance with the terms.
I mean, he would still have to qualify. He's not one of these
Let me
recognized
make it
parties.
clear, this applies only to statewide elections. It doesn't apply to individual counties.
He said prohibition and the vegetarians and all the other people have already qualified. They are
my understanding, sir.
even Republicans, of course, we want to leave those out. But Mr. Freeman's Free Democratic Party would have to requalify, is that right?
That is my understanding, sir.
Any other questions? Mr. Moore?
Mr. Barry, one question I have in mind. What is the qualified voter in the state of Tennessee? Has that ever been determined?
I think it has been determined for the purpose of signing a petition of this sort, Mr. Moore. There's some question as to the identity and qualifications of a qualified voter for certain constitutional purposes. I don't think there's any question but that a voter who's registered and qualified to vote in a given election can sign a qualification petition of this sort. I think you're referring to the question that's been raised on various occasions as to a qualified voter for the purpose of enumerating the same under the provisions of Article 2 of the Constitution of Tennessee.
Thank you.
All right, that seems to be all the questions. Will we move to the passage of the bill? All members in favor of the passage of the bill vote aye when the bell rings. Those opposed to the passage of House Bill 288 vote no. Each member will cast his vote when the bell rings. Has every member voted? Does any member desire to change his vote? Mr. Clerk, record the vote.
74 ayes and 4 noes.
Bill having received a constitutional majority, I declare it passed. Without objection, the motion to reconsider goes to the table. Mr. Edmonds, how do you vote? Aye. Vote, Mr. Edmonds, aye.
Senate Bill number 234, House Bill number 288 on the same subject as on the clerk's desk, relating to the duties of the chairman of the Board of Election Commissioners in placing names on ballots.
The gentleman from Shelby County so to come.
Mr. Speaker and gentlemen of the Senate, first I'd like to move that this bill conform and substitute.
The House bill on the desk.
Yes, sir.
Without objection, Senate Bill 234 be made to conform to House Bill 288 and House Bill 288. Substitute on account of the Senate Bill 234. Gentleman from Shelby County on the bill.
Mr. Speaker and gentlemen of the Senate, this bill defines a political party. And if enacted, it will eliminate splinter parties and groups which may claim to be parties without being such. Any person who may want to qualify as an independent candidate, of course, may still do so. If there are no questions on this bill, I move its passage on third and final reading.
Any questions? Gentleman from Scott County, Senator Chair.
Mr. Cobb, you yield the question.
Yes.
We've discussed this. Not being a lawyer, I can't come to a complete understanding now. In a presidential election, would this eliminate candidates such as Senator Thurman Morris, 48, I mean, the States' Rights Party would that eliminate them from putting their candidates on the ballot for president? Or
no, sir, I don't think it would. They couldn't, they would run as an independent candidate.
I mean, we're eliminating the States' Rights Party as it was in the 48 election in from Tennessee.
I don't think it would, sir. 21, no
The bill having received a constitutional majority is declared passed without objection. The motion reads and Senate vote table.